civil cases and 73 criminal cases. The man died in 2001 and only one case was decided, that was also relating to the bouncing of check, a very small case. This is what? The justice is moving slower than a snail. Look at the appointment of judges. Very interesting. You know the collegium system? Your Vice Chancellor is expert of Constitution, I am not, but Constitution is close to my heart. Collegium system was evolved by the court itself. Chief Justice of India and 4 judges of the Supreme Court will decide who should be appointed as a judge in the High Court or the Supreme Court and who should not be. There is no mention in the Constitution of India about this kind of collegium system. And before that, it started only in 1993. It started with the CJI plus 2 Supreme Court judges. Later on, it was changed to 4 Supreme Court judges plus CJI. Since before that, the judges used to be appointed by the President of India with consultation with the Chief Justice of India. That was the system. What was wrong with that system? No. Suddenly, the judges said, we will appoint the judges. Who are you? Where is the Constitution spirit? We talk of Constitution spirit. You see, in India, we use very high sounding words. Constitution spirit is lost. Where is the Constitution spirit vesting power to the judges to appoint judges? Where is that power? And okay, the government, the central government, made a law, NJAC Act 2014. Many of you must be knowing. National Judicial Appointment Commission. Along with the Constitutional Amendment, 99th Constitutional Amendment. This was perhaps the law which was unanimously passed by both the houses of parliament. Unanimously passed by both the houses of parliament. Ratification by the requisite number of states. Challenge in the Supreme Court. A 5-judge bench headed by Justice Kehar. Judgment 4:1. This act is ultra virus, the Constitution. Why it is ultra virus, the Constitution? A very simple, repeated sentence. Interference in the independence of judiciary. Judiciary has the only independence, no other institution has independence. Interference in the independence of judiciary, therefore the act is struck down. Act was passed in 2014, challenged, and the judgment is 2015. Look at. Otherwise, Supreme Court has no time to decide cases. But what was the urgency to decide this case? हमारी पावर हाथ से ना निकल जाए. Why judges should appoint judges? Are they above board? Are they above from political bias? Are they above from human bias? Perhaps nobody in the world is free from these bias. Nobody in the world. Ultimately, that act, and that was, you know, the act was so meticulously framed. Chief Justice and two Supreme Court judges, Chief Justice of India and two Supreme Court judges happened to be the member of that committee which was to recommend under the new act, 2014 act. Judiciary was again getting an important role. And even two nominees which are to be made in this committee for selection, in that also CJI, Prime Minister of India and the leader of opposition, they were to recommend two names, to nominate two names. Still, it is interference in the independence of judiciary. Every institution in a democracy is accountable. Prime Minister of India, along with the Union of Ministers, is accountable to the Parliament. President of India is accountable to the Constitution. But about the judges? They are accountable to none. The only provision which we have in the Constitution is impeachment. And in the history of this country after independence, more than 75 years, only one case of impeachment came to the Parliament, that was relating to V. Ramaswamy, who happened to be Chief Justice of your state, Punjab and Haryana High Court. And there were charges of misappropriation of funds. He spent money like anything on his own residence as the Chief Justice of Punjab Haryana High Court. Charges were proved by a committee constituted by the Parliament. Beyond doubt, those charges were proved. But on the date of voting, the then ruling party absented from the Parliament. The then ruling party absented from the Parliament. In what direction we are going? Is it the spirit of the Constitution? And I don't know what is going to happen to the case which Honorable Judge was referring to, where half-one notes were recovered. I don't know whether that impeachment is going to be successful or not. This is what the situation. Now, a new thing has emerged. The judges, which I was sharing with your Vice Chancellor also, the judges are making, sometimes unwarranted statement, irrelevant statement where you are sitting. You are presiding over a bench of the apex court. You must have heard a recent case when an advocate approached the court seeking that I must get the right to worship a deity. What the judge said? You go to the deity and ask him. Where was the need to make this statement? Was there any need? Such kind of loose statements, such kind of unwarranted statements, such kind of unnecessary statements, at least I have not seen, at least up to 80s or 90s. These are most recent trends. A new thing is happening. So when we talk of Viksit Bharat, we have to think of how to reform our justice delivery system. I always say that the courts are no more the courts of justice, they have become the courts of law. justice that have become the courts of law. I give you a very simple example of this. This happened in Punjab. A murder trial was going on. A poor young boy was caught in a murder case by the police. Ultimately, after the trial, he was sentenced to death. His mother was present in the court. She cried, "Judge Saab, insaf nahi hoya." You know what the judge replied? "Mata ji, asi ithe insaf nahi karde, asi te faisle sunande ne." I'm not fluent in Punjabi, but this was what happened in that case. We do not do justice, we pronounce judgment. It is the common man of this country requires judgment or the justice? Justice. So obviously, Viksit Bharat means justice for all. Justice to the person standing in the end of the row. Justice in rural areas, justice in remote areas, justice in tribal areas. Then our dream of Viksit Bharat will come true. Expensive justice, all of you know. You have to pay the court fee and also the lawyer's fee. There is no law to regulate the lawyer's fee. There are lawyers who charge fee without your beyond your imagination. There are one of the lawyer, I will not take his name, he was charging 1.21 crore as retainership fee for a month from a corporate. 1.21 crore. You have more money, engage accordingly the lawyer of that status, and you have a chance to win the case. This is our psychology also. Just by way of lighter vein, a person was involved in a murder case. He approached a young lawyer who has passed out from law school 5 years. He said, "Kya chalo shuru hai, practice." Client to aaya. He said that, "How much fee will you charge for my murder case?" He said, 5,000. Useless lawyer. He approached another. "How much fee you will charge?" He said, 50,000. No, he's not a good lawyer. Murder trial, 50,000, nothing. He approached the third one. He said, 5 lakhs. Yeah, okay. He will be able to get me scot-free. Ultimately, a day came, he was sentenced to death. जब वो कोर्ट से बाहर निकल रहा था, the same lawyer met him, who asked for 5,000. So out of anxiety, asked, "What happened to your case today?" He said, "होना क्या था? फांसी की सजा हो गई, क्योंकि ये काम मैं 5,000 में नहीं करवा रहा था, जो तूने 5 लाख में करवाया." This is what the human psychology also, by paying more fee, we are likely to win the case. There are many other issues if we talk of relating to the Constitution. Executive less said is better. Executive believes only in one slogan: "Show me the face, I will show you the rule." So rules are made according to the face. But in India, you will find, as the Constitution is concerned, the executive is playing dual role: lawmaking as well as executive powers. So Devinder must be looking at his watch. You see, कि क्या है ना, जैसे कवि होते हैं ना, उनको कोई सुनने वाला मिल जाए छोड़ते नहीं है. ऐसे ना टीचर का भी प्रॉब्लम है, अगर उनको ऑडियंस ना शांति से सुनने वाली मिल जाए, उससे 1 घंटे का लेक्चर कर ही लेते हैं. But anyhow, I will not take more time. So, you see, I say one thing, that law in books is different from law in action. What you study in books is just the guiding factors, but when you will be going for implementation of those laws, and you will be going for using those laws, you will find the scenario is different. I give you a very simple, real example of this. Smoking, you know, is injurious to health. On every cigarette packet, there must be a print line. Smoking is injurious to health. Firstly, the marketing people are very smart. They will be printing that line in such a color scheme you cannot make out. There used to be an advertisement on, you see, when you go to see a film on a theater, you will find that advertisement. What is that advertisement? There is a fire in the house. People have come out of that fire. One young girl is left. People are crying, save her, save her. A young man jumps into the fire, brings that girl safely. Everybody is very happy. The life of the girl is saved. Somebody asked from the crowd, where is that gentleman who has saved her life? The gentleman standing under a tree, smoking. Caption, चार मीनार पीने वालों की बात ही कुछ और है. And there's another caption, statutory warning, smoking is injurious to health. Now what to follow? They are showing चार मीनार पीने वालों की बात ही कुछ और है. Heroic act, saved the life of a girl. Statutory warning, which is law in books, not law in action. So with these, observations, I once again extend my heartfelt thanks, and I'm grateful to the organizers of this event, and particularly the Vice Chancellor, the Director, the HOD, who have provided this opportunity to interact with the young boys and girls and the distinguished faculty members of this university. Thank you so much.
Once again, we express our deepest gratitude to Professor Dr. V.K. Agarwal for sharing his valuable perspectives and enriching our understanding of constitutional values. We are truly grateful for your eloquent articulation of the challenges and responsibilities that come with being citizens of a constitutional democracy. Your address has added great meaning to the celebration, reinforcing our collective duty to uphold the spirit of justice, liberty, and equality in all that we do.
I now request Honorable Vice Chancellor Sir to kindly present a memento to Professor Dr. V.K. Agarwal Sir as a token of appreciation. Thank you, sir. I now have the honor of inviting Dr. Pooja Jaiswal, Associate Professor of Law and Head of Department, Dr. B.R. Ambedkar National Law University, Sonipat, to deliver the vote of thanks for this inaugural session. Ma'am, your deep engagement with constitutional discourse adds immense value to this conclave. We request your esteemed presence on the dais as we reach the closing of this inaugural session. Over to you, ma'am.
Thank you, Yash. Namaste and good afternoon to you all. Honorable Mr. Justice Adarsh Kumar Goyal ji, former Judge, Supreme Court of India. My Guru, Professor Dr. V.K. Agarwal ji, Pro-Chancellor of Jagannath University, the Vice Chancellor of the University, Professor Dr. Devendra Singh, Dr. Sanjay Kumar, the Conference Director, esteemed scholars, distinguished guests, faculty members, and dear students. I would say that this day marks a very, very important day where we begin with the event, where we are celebrating the 76th year of our Constitution. Today on this day, we also mark the 77th NCC Day. So before I propose my vote of thanks, I would request our Honorable Vice Chancellor to kindly felicitate Professor Dr. Agarwal with the sapling, and I would request from the NCC unit, Dr. Kulwant Singh Malik to join with the felicitation. Please. I would like to also inform the gathering here that for NCC, approximately 20 students of this university have been shortlisted. A huge round of applause for the students of this university. In the background. So, my deepest thanks to our chief guest, and I would say that, sir, very meaningfully woven the entire fabric, bringing into how the principles enshrined in our constitution, how we look at the role of Rama, how in Mahabharata, he also talked about certain shlokas from our Rig Veda, and also that's how the architect of our constitution, Dr. B.R. Ambedkar, in whose name this university stands as the National Law University of our state of Haryana, and how liberty, equality, fraternity is important for every citizen of this country. Thank you so much, sir, for joining us online today, and as our Vice Chancellor, sir, said that we in near future look forward to your presence in the campus. I would now extend my heartfelt thanks to the keynote speaker, my guru, Professor Dr. Agarwal. I would say that with what passion sir used to come to the class where Dr. Sanjay and I were students, I could see that same passion here. And again, I became a student. I kept on writing. Every day is a learning. And that day was again here where I could note down so many things which not only opened, I would say, a debate for all of us to rethink that how we are to achieve these goals of Viksit Bharat. If I could see that sir touched upon a very, very important aspect, that why laws not in the language that we understand. When we talk about equality, when we talk about justice, it is that how the best we can give to the person who is at the farthest end. So thank you, sir, for sparing your time and giving us the opportunity, giving the opportunity to these young minds to think again. My heartfelt thanks to our Vice Chancellor, Sir Professor Dr. Devendra Singh, for his address where he primarily invoked that how collective responsibility of the students, faculty, and the administration will actually live up to the principles of this university and how the vision and goals can be achieved. I thank sir for his address and also for his support and guidance, what he keeps on. He is available to us even in the evening hours, guiding us how we can, best way we can culminate events in the interest of the public and for the students to take this strive further. Last but not the least, the Center Director, Dr. Sanjay Kumar, and the entire organizing committee, the IT support staff, and all volunteers for their meticulous planning, tireless efforts in making this conference a seamless success. Now, as we are coming to the end of this inaugural session, all the participant faculty members, students, now the stage is set for your deliberations. What has been conveyed to us, the understanding that has been given to us by the Honorable Chief Guest and the keynote speaker, how the deliberations would be done in the entire day. And I look forward that through these deliberations, we make our constitution live up and a living document with our wisdom, understanding, and with our courage as well, and shall attain the goals of Viksit Bharat 2047. Thank you so much. Jai Hind.
Thank you so much, ma'am, for expressing your heartfelt gratitude towards our dignitaries and participants, and obviously the organizing team of the conclave, and also incorporating the spirit of the 77th NCC Day with the conclave. I would now like to request you all to kindly stand up for the national anthem. Thank you.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Please be seated. With those profoundly inspiring words from our dignitaries, we now draw the inaugural session of our national conclave to a close. To our esteemed chief guest, keynote speaker, and resource persons, we extend our deepest and most sincere gratitude for gracing us with your presence and for sharing your invaluable constitutional wisdom. Your insights have set a powerful intellectual standard for the days ahead. We express our thanks once again for lending your time and prestige to our institution. To all our delegates, participants, and students, the work now commences. The goal of this conclave is not to simply observe our constitution,